Question is that this bill be now read a second time. I call the honourable member for Fadden.
Thank you, Mr Deputy Speaker. I rise to speak on the Federal Circuit Court of Australia Legislation Bill 2012. The purpose of this weighty bill of great substance and noble cause is to change the name of the Federal Magistrates Court to the Federal Circuit Court of Australia. And I have 30 minutes by which to outline the impact of this judicious change of name to the Judicious Court. By way of history, which is always instructive in these matters, the Federal Magistrates Court was established by the Howard government 12 years ago in 2000 in order to provide for timely, efficient and less formal adjudication of disputes in the federal jurisdiction. One should always question, when one changes the name, whether indeed the court has been effective. And I think, looking at its history, its throughput and its efficiency, it can be said that it has been very successful. In fact, in 2010-11 financial year, it finalised over 90,000 matters, which included family law, migration, bankruptcy and consumer protection. In fact, the court now deals with 86% of all family law matters, up from 60% in 2004. 84% of all applications filed are completed within 6 months, a staggering testimony to the efficiency of the court. But here's where the debate gets a little interesting, isn't it? Because in 2008, the Rudd-Gillard government sought to abolish the court. Abolish a court that is moving through 84% of matters within 6 months, that has dealt with 90,000 matters in the calendar year. Clearly a court so effective, so numerate, so efficient, couldn't possibly be allowed to stand within the halls of the government's sheer incompetence with everything else. Strongly opposed by the Federal Magistrates Court, which opposed, of course, the government's move, successfully resisted by the coalition the federal court stands today. Earlier this year, the Attorney-General conceded defeat to her credit and instead proposed that the court be maintained under a new name to reflect its expanded workload and jurisdiction. Hilarious that the Attorney-General is happy to recognise the expanded workload, yet only by realising she didn't have the numbers in the House and therefore couldn't move to demolish it. In so doing, the Attorney-General accepted the recommendation of the federal judiciary, which itself adopted the policy announced by the coalition in the 2010 election, including our own nomenclature. Well, flattery, of course, is a marvellous indication of that which is right and good. It's simply a shame that the government's maladministration of the courts has now resulted in the new circuit court having to curtail its circuit sittings. It should be noted that the bill will in effect continue the Federal Magistrates Court in existence. It will simply change the name to reflect the wider work that the court is now doing as a great workhorse within the judiciary system in our country. The bill will not alter the jurisdiction or the status of the Federal Magistrates Court and the arrangements under which it operates, which is fabulous to see the government not touching something that works. It would be great if the government could take that degree of thoughtfulness across the rest of the areas of public policy where its current Midas touch is turning everything into a complete disaster. Now, changing the name of the court, of course, is not intended to create a new separate federal court or changing existing arrangements. It is, as it is, a bill to change the name of the court. It's for these reasons I commend the bill to the House. I don't believe the coalition wishes to address the matter in any more depth, looking at my senior colleagues, and I simply pass it across to the Minister at the desk to sum up and conclude this weighty debate on this issue.